Hello and welcome to the Law Lab. Here, we dissect and unpack everything legal. My name is Risa Iris Ewonia, and today I'll be introducing you to what we call land law. When we mention land law, many people tend to think of the surface soil because they believe that land is necessarily what we see on the floor or on the ground. But land goes beyond that. And we can see that in certain decisions that have been made by the courts, in our statutes, and also in books that have been written. In Oleinu and Woodman's book, which is titled Principles of Customary Land Law in Ghana, of which is being displayed on the screen, they define land as it includes the land itself, that is, the surface soil, things on the soil, which are enjoyed with it as being part of it by nature. That is rivers, streams, lakes, lagoons, creeks, growing trees like palm and dawadawa trees, or things artificially tied to it like buildings and any other structure whatsoever. It also includes any estate, interest or right in, to or over the land, or over any of the other things which land denotes. That is, right to collect herbs or snails or to hunt on the land. By this definition alone, you can determine that land is not just the surface soil. Anything that is found attached to the land, which is natural, something like trees, rivers, or lakes, also form part of the land. Buildings that have been put on the land also form part of the land. And even the right and interest you have in the land is also part of the land. This definition has also been reflected under the interpretation of the Lands Act 2020 Act 1036, and it has been defined as land includes a solid surface of the earth, trees, plants, crops, and other vegetation, a part of the earth's surface covered by water, any house, building, or structure whatsoever, and any other interest or right in, to, or over immovable property. So from these definitions, you can determine that land is not just the surface soil. From the definition of land which has been given, you can see that hereditaments also form part of the land. Now, hereditaments is any physical thing or intangible thing that is attached to the land. Under land law, we have two types of hereditaments, which are corporeal and incorporeal hereditaments. Now, corporeal hereditaments are physical things that have been fixed and attached to the land, which have formed part of the land. Ordinarily, if a person attaches anything to the land, it should form part of the land. And this has been reflected in the Latin maxim, which is being displayed on the screen. I'll shorten this as the quid planter too, but I'm sure you see the full thing on the screen, which means that whichever is attached to the land forms part of the land. So if a person is to, say, construct a well on their land, it forms part of the land. And by this maxim alone, you understand that even if a person is to add a TV to their house or maybe install a fridge, you would ordinarily think that it forms part of the land. But in Ghana, there are two types of corporeal hereditaments which will determine whether the thing added to the land forms part of that land. These two types are fixtures and chattels. A fixture is anything which has been added to the land of which the ownership devolves from the individual who added it to the land and forms part of the land. So say, for instance, if a person is to construct a well on a land, even though person A constructed that well, if person A is to sell the land to person B, the well forms part of the land and it moves on from person A to person B because the fixture, which is the well, has formed part of the land. To determine whether a thing added onto the land is a fixture or a chattel, you need to determine the intention of the owner. And that can only be determined by finding out the degree and purpose of annexation of the thing onto the land. If the thing added to the land is such that if it is removed, it is going to substantially damage the land, or it is one that when added to the land, it makes living on the land easier, it becomes a chattel. The case of Nelson and Bridport explains this principle adequately. which has been displayed on the screen. However, if the thing added onto the land is one that is going to beautify the land, and if it is something that when removed, it's not going to substantially damage the land, it does not form part of the land. And if it doesn't form part of the land, it is not a fixture, but it is rather a chattel, because chattels, when added onto the land, they do not devolve and attach itself to the land, but rather it attaches its property right to the owner. So if the owner is to move away from the soil, the surface soil, the thing that was added onto the land moves along with the owner. An example is a fridge. Even though when you move into a rented apartment, you may bring a fridge or a TV or couch or whatever thing you want to beautify your place, it does not form part of the land. Because if you remove the TV or the fridges, it does not cause any damage to the land, or even if it does, it's not a substantial damage. So such things become chattels and they do not form part of the land. However, the definition of land, which was captured under Section 281 of the Lands Act, also makes mention of rights and interests. And these rights and interests are what we call incorporeal hereditaments. Incorporeal hereditaments are properties of persons which cannot be seen or felt. So a person may say that I have an interest in a land at Medina. That particular interest you have is also part of the land. So land is not just the physical things you see, but the rights and interests you have attached to the land. The definition of land, which made mention of rights and interests, also talk about the rights of persons that are attached to the land. Now, under common law, there's a Latin maxim which was being displayed on the screen. I cannot pronounce the full thing, so I'm just going to leave it to my viewers to be able to read it and pronounce it the way they want. But that maxim means that whoever owns the soil owns everything up to the heavens and down to the depths of the earth. This basically means that if you own a land, the airspace above the surface soil and everything below the earth space, below the surface soil, ordinarily is supposed to form part of the land. So if a person is to enter your property and use your surface soil or anything below it or your airspace without your consent, it will be a trespass. However, there are exceptions to it, because you know that in law, whenever there's a general rule, there's always an exception. Article 257, Clause 6 of the 1992 Constitution of Ghana, when paraphrased, basically states that any minerals or water bodies that are found under or above the soil belongs to the state, which the president holds in trust and on behalf of the people of Ghana. So this particular provision of the Constitution is an exception to the Latin maxim, because you may find a mineral under your land or above your land, for instance, gold or bauxite, but it does not belong to you. Even though it is something that came naturally out of your land, or maybe you mined it, it does not belong to you. It belongs to the state. And it is the president who holds it in trust on and behalf of the people of Ghana. Even if you want to mine the gold or the bauxite you found on the land, you need a mining concession because it is not yours. It is for the people of Ghana. So this is one of the exceptions to the Latin maxim, which states that whoever owns the land owns everything up to the heavens, down to the surface soil beneath. Another thing, which is also another exception, is that ownership of economic trees on land is not the same as ownership of the surface soil itself. In Ghana, we have people who have cocoa farms and timber plantations. Even though those people own those farms and plantations, it does not necessarily mean that they own the surface soil itself. So this is an exception to the rule. The case of Dazi and Kokofu makes it perfectly clear that ownership of cocoa farms in Ghana does not necessarily mean that the person also owns the surface soil. The cases in point which address the mere fact that you own a land does not necessarily mean that you own everything attached to the land are in the cases of Kelson versus Imperial Tobacco, Bernstein versus Sky Views and General Limited, and Putney and Clayton, which I'm sure have been displayed on the screen. Now, in the Kelson versus Imperial tobacco case, the facts are very simple. A person attached a banner onto the land, which projected about 8 inches from the plaintiff's land. So he argued that the banner which entered his land was trespassing on his airspace. So when he took it to court, the court agreed with him that indeed, even though he owns the surface soil, that he also owns the airspace. So anything that affects his airspace without his consent is a trespass to him and his property. So the case turned out in his favor. However, in the Bernstein versus Skyviews and General Limited case, even though the plaintiff was arguing that the aerial photograph that was taken above his land was a trespass to his rights, the court reasoned that the pictures that were taken were too far away from the property to ordinarily be classified as being attached to the plaintiff's land. So it did not form, or neither did it trespass on the plaintiff's surface soil or his land. So this is clearly in contention with the Kelson versus Imperial tobacco case. As a form of recap, we should know that land is not necessarily only the surface soil, but anything found below it in the airspace or anything attached to it, including the airspace above the land. So land includes buildings and trees and the surface soil, plus your rights and interests attached to the land. In our next video, I'll explain the various interests that are attached to land in Ghana. Thank you for your time.